Welcome to today's Explainer. I am so thrilled to have you here because we are about to unpack just a truly fascinating legal journey. We're looking at a case from South Africa, specifically a judgment from the Constitutional Court, which is literally the highest court in the land. It's the case of Dikoko versus Mokala. Now, normally, petty workplace disputes over a small expense, they end with a stern email or, a quiet trip to HR. But not this one. We are going to trace how an incredibly petty, everyday dispute over a municipal expense skyrocketed through the legal system until it touched on the very foundational values of human dignity, democratic immunity, and restorative justice. It's an absolutely brilliant example of how small actions can trigger massive constitutional debates. Okay, let's dive into this. How does a seemingly trivial dispute over a cell phone bill end up sitting in front of the nation's most senior judges? I mean, how does it spark a profound philosophical debate about the actual price of a human's reputation? Well, to understand this massive legal fire, we have to look at the spark. Section 1. The cell phone bill drama. Our story starts in the offices of a local municipality in South Africa's Northwest Province. We have two colleagues, the executive mayor, David Dikoko, and the chief executive officer, Thobi Mokatla. And right at the center of their conflict, 3,200 rand. In the grand scheme of government budgets, that is essentially pocket change, right? But this exact amount of excess debt, which was racked up by Mayor Dikoko on his official cell phone account, was the catalyst for literally everything that followed. It just goes to show that in law and governance, it's rarely just about the money. It's about the principle and how people behave when they're actually held accountable for that money. So let's walk through exactly how this escalated so rapidly. The council had a pretty standard policy. They pay a basic allowance of R300 a month for a councillor's cell phone. Anything above that has to be justified, or, it comes out of the councillor's own pocket. Well, Mayor Dikoko accrued an overdue excess of R3,200. Mr. Mokatla, the CEO, repeatedly brought this to the mayor's attention, but the debt just sat there unsettled. Eventually, the provincial auditor general stepped in, flagged this overdue debt, and expressed official dissatisfaction. This forced a formal action. Mayor Dikoko was actually summoned to appear before the Provincial Public Accounts Standing Committee to explain his personal indebtedness. Section 2. The defamation lawsuit. Now, what's really interesting here is what happened next. When cornered about his personal phone bill before the committee, Mayor Dikoko didn't just, explain his finances. He went on the offensive. Instead of taking responsibility, Dikoko shifted the blame entirely onto CEO Thobi Mokatla. He told the committee that his indebtedness was politically motivated. He claimed that Mokatla had deliberately changed accounting procedures just to let the debt build up into a large sum, specifically to give political opponents a basis to attack his integrity. He was essentially accusing the CEO of a calculated bad faith political hit job. The kicker? Mokatla wasn't even in the room to defend himself. So what does he do? He sues Mayor Dikoko for defamation in the High Court. And the court actually agreed with Mokatla. They found that Dikoko's statements carried a very specific, damaging meaning, that Mokatla was devious, manipulative, lacked the independence required of a CEO, and was pushing a political agenda. These accusations struck directly at the heart of Mokatla's professional integrity and his fitness for senior administrative office. Section 3. Limits of political immunity. Rather than apologizing or just paying up, Mayor Dikoko invoked a major legal defense, escalating a local feud into a full-blown test of constitutional law. He entered a special plea of privilege. Now, in a constitutional democracy, elected officials are granted certain immunities from civil or criminal liability for things they say while doing their official jobs in council or committee meetings. This is an absolutely crucial bulwark of democracy. It exists so councillors can debate freely, expose corruption, and speak openly without the constant fear of being sued into bankruptcy. It's designed to protect honest debate and whistleblowers. And this brilliantly illustrates the core conflict the judges had to resolve. Was Dikoko doing the legitimate business of the council when he made those statements? Or was he just making a personal excuse? Dikoko argued that because he was speaking at a standing committee meeting, he was automatically covered by this political immunity. He essentially tried to use a constitutional shield, one designed for democratic oversight, to deflect a lawsuit about a gratuitous personal attack regarding his own cell phone bill. While the court saw right through this, both the High Court and eventually the Constitutional Court firmly rejected Dikoko's plea of privilege.
The Constitutional Court noted that DeCoco's appearance regarding his cell phone account did not constitute the legitimate business of the council. He was summoned to give a personal explanation for a personal debt, and he used that moment to launch a totally unwarranted attack on Mahatla. Therefore, he was acting completely outside the bounds of his official executive functions, and the defamation charge stuck.
Section 4. The price of a reputation. So, with the immunity defense completely thrown out, how does the law actually calculate the monetary value of a damaged reputation? The High Court answered with a staggering number, 110,000 rand. Just think about that for a second. A dispute that started over an excess phone bill of R$3,200 has now ballooned into an $110,000 penalty for character assassination. DeCoco appealed this quantum of damages all the way to the Constitutional Court, arguing it was wildly excessive and disproportionate. This set up the ultimate conflict at the highest court in the land over whether this specific price tag was fair.
The Constitutional Court actually split on this issue, and the reasoning on both sides is just fascinating. On one side, the majority, led by Deputy Chief Justice Mozenike, upheld the R$100,000 fine. Their logic was more structural. The assessment of sentimental damages belongs properly to a trial court. An appellate court shouldn't just interfere because they might have, chosen a different number. They felt the High Court reasonably exercised its discretion to vindicate Mahatla's human dignity. But then you have the minority view, led by Justice Magoro and Justice Sachs, who argued the fine should be reduced to $50,000. They pointed out that the trial court completely ignored mitigating factors. For instance, the defamation was only published locally, and Mahatla's career wasn't actually ruined. In fact, he had since been appointed as a municipal manager in another high public office. The minority felt $100,000 was overly punitive rather than just compensatory.
Section 5. Ubuntu and restorative justice.
So, the crucial point is, while the majority ruled to keep the higher fine, the minority justices introduced a profound philosophical perspective that fundamentally challenges how we handle defamation. They brought the South African constitutional value of ubuntu, or botho, into the legal realm. Ubuntu represents human solidarity, compassion, and the idea that our humanity is interdependent. Justice Magoro linked this directly to the historical Roman-Dutch legal remedy called the amende honorable. This was an old remedy focused strictly on a public apology and retraction to restore someone's honor, rather than just handing over cash. The justices argued that the law should really focus on repairing ruptured relationships, restorative justice, rather than just punishing the offender with retributive justice.
Just listen to this powerful quote from Justice Sachs. Unlike businesses, honor is not quoted on the stock exchange. It brilliantly highlights the conceptual incongruity of trying to measure intrinsic human dignity as a marketplace commodity. I mean, how do you establish a proportionate relationship between someone's reputation and a stack of rands? A damaged reputation is either restored or it isn't. You can't be more restored by a higher financial award. Let's see how this builds, because the minority justices pointed out a glaring flaw here. DeCoco never actually apologized. If the legal system encouraged apologies rather than just focusing on cash payouts, it would do far more to knit together shattered communities. A sincere apology recognizes the inner humanity of the plaintiff. It clears the air. By treating defamation strictly as a financial transaction, the legal process actually drives people further apart, creating a winner who might gloat and a loser who is financially ruined, leaving the actual interpersonal relationship completely broken. Which leaves us with this final, provocative thought. As we've seen through the incredible escalation of a pocket change R$3,200 cell phone bill, our legal systems are highly tuned to argue over money and constitutional immunities. But when it comes to the core of human dignity, we really have to ask ourselves, what truly restores a damaged reputation? Is it a massive monetary payout that punishes your opponent, or is it the restorative power of a sincere public apology? It's a delicate balance between money and dignity, and a profound question to ponder long after this explainer ends. Thank you so much for learning with me today.